I am indeed honored to deliver this inaugural lecture in this very, very innovative and thought-provoking step taken by the Supreme Court Bar Association in reviving, if I may use that expression, the academic part of the bar. I am indeed honored to deliver this lecture in the presence of my esteemed colleague, Justice Sikri, the learned attorney, Mr. Venugopal, the learned Additional Solicitor General, Madam Madhavi Diwan, the eminent member of the bar, Mr. Datar, and the office bearers of the Supreme Court Bar Association, Mr. Khanna, Mr. Yadav, Mr. Sharma, and all the learned members of the bar. I compliment the bar for choosing the topic, role of directive principles in enforcement of fundamental rights. Ladies and gentlemen, the march of civilization primarily charts the journey of human beings, mostly as a part of a race or a group or a commune on that scale of time. Across centuries, evolving modes of transport and communications, amongst other reasons, brought varied human groups or communes closer, thereby triggering and enabling a continuing exchange of thoughts and experiences across such groups and communes. Such exchange and synergy led to rapid enrichment of what may be denoted as the collective wisdom of the human race. The advent and evolution of modern nation states was primarily an outcome of such collective wisdom, as egalitarian thoughts of liberty, equality, and fraternity of all human beings came to hold the center stage in discourses across communities. In all of this, the world wars between the nations and their horrifying outcomes also injected into such collective wisdom the realization that peaceful and mutual coexistence was the only way ahead to usher in economic well-being and advancement in the quality of life on the planet. Around the same period of time, the ancient land of Bharat witnessed the march of its people through centuries of inequality and oppression, the tales of which only inspired their successive generations to aspire for the goals of equality, liberty, and fraternity of all human beings. The emergence of India as a sovereign republic from its dark age under the imperialist forces culminated in framing of the vision document, the Constitution of India. We must remind ourselves that our Constitution is not only a reflection of such enriched collective wisdom that evolved through the lives, pains, and sacrifices of our ancestors, but is also an aspirational document of our forefathers who, through their constituents, sought to lay down a charter for themselves as well as for the future generations. The emergence of nation states also witnessed recognition of state policy as an important and inseparable constituent of every such vision document. State policy would broadly refer to the nature and character of governance that was envisioned and would imply and include all government's goals that a nation state would pursue and strive for on behalf of the constituents. In our Constitution, Part 4 laid down the directive principles of state policy, which are in the nature of goals that the Indian state would seek to pursue in all its actions, especially in areas of legislation and governance. In such light, the provisions of Part 4 were meant to be dynamic and evolving as they were required to guide state policy and governance through the changing times and the varying aspirations of the Indian population. It is this view of the directive principles of state policy that needs to be remembered to understand their role in implementation of the fundamental rights. The aim of the founding fathers of the nation, in including the directive principles in Part 4, was thus to lay down principles that would guide actions of the state and its agents, including the actions of the legislature and the executive. It is imperative to understand that the Constituent Assembly never meant the directive principles to remain static as they were at the inception. Realizing that implementation of the directive principles would be hugely influenced by the prevalent social, political, and economic realities of our nation, the Assembly deemed it proper to keep such principles in Part 4 non-justiciable. In other words, the Constituent Assembly laid its trust on the wisdom and the acumen of the coming generations in deciding what contemporary state action would be like, provided that no such action would be in violation of the principles laid down in Part 4. It emerges then that the directive principles of state policy would set the benchmark of state action in respect of areas covered by them, and as such, the legitimacy or otherwise of any act of the state and its agents in respect of such benchmark would certainly be weighed in the light of the principles in Part 4, even though an action seeking to enforce them simpliciter would not be maintainable. Some instances of the benchmark I may cite: the case of Hanif Qureshi. A portion of the cow slaughter prohibition legislation was upheld in deference to Article 48. In Kameshwar Singh's case, distributive justice enshrined in Article 39B and C of Part 4 were accorded priority while upholding the validity of the Bihar Land Reforms Act. State of Bombay versus Balsara, the concept of prohibition as laid down in Article 47 of Part 4 influenced the decision to uphold the validity of the Bombay prohibition law. To understand the dynamism involved, it is relevant to draw a reference to a bundle of facts that in effect brought about a paradigm shift in the role of the directive principles of state policy, more particularly in interpreting and implementing the rights in Part 3 of the Constitution. The federal polity of our republic that was envisaged at the commencement of the Constitution to be a vibrant multi-party dynamic system witnessed unprecedented upheavals in the political discourse over the decades, and that is said to have impacted legislation as well as governance goals and their implementation. This, to my mind, led to a complete standstill in some areas and directionless motion in others. Such impact appears to have dented the faith and the confidence of the people in public institutions connected with legislations and public policy, and almost as an outcome thereof, concerned citizens started bringing public-spirited plaints before the constitutional courts alleging gross violation of the constitutional mandate at several levels of governance. Such plaints eventually came to establish the remedy of public interest litigation, as such courts, namely the constitutional courts, were called upon to examine the gross violation of fundamental rights of the public in general by acts of omission and commission by the state and its agents, as well as the lack of state policy assigned thereto. In doing so, the scope of the terms life and personal liberty, as well as of various freedoms under Part Roman 3 of the Constitution, got redefined and came to be expanded on the matrix of the principles enunciated in Part 4. Some examples would be protection of ecology and environment from pollution, as enshrined in Article 48A. This got read into the expanding scope of Article 21. Right to free legal aid under Article 39A, which got read into the expanding definition of right to life and personal liberty under Article 21. The principles enunciated in Article 41 and 45 were relied upon when right to education was recognized as a fundamental right under Part Roman 3. The principle laid down in Article 47 was relied upon when the right to personal liberty was declared to include the right to good health. So on and so forth, we may carry on. Having said all that, I would like to draw your attention to another vital role that the directive principles of state policy play in implementing the fundamental rights. My emphasis being on the word implementing as contrasted and distinguished from the word enforcing, which is the subject matter of today's lecture. On a broader framework, implementing would imply affirmative and voluntary state action in line with and with due accordance to the fundamental rights of the individual affected by such action, whereas enforcing would have as its starting point the very failure or absence of such affirmative and voluntary action on the part of the state and its agents. The very existence of fundamental rights for individuals, together with a mechanism for the enforcement by courts, would reflect that the society is governed by the rule of law, but it is also a requirement of the rule of law that the conduct of individuals, including conduct in the exercise of their fundamental freedoms, needs to be regulated by law to the extent required to harmonize it with the overriding interests of society or the public at large. It is in respect of such regulation that the directive principles of state policy play a vital role by laying down the four corners within which such affirmative and voluntary state action would have to remain, so as to uphold the fundamental rights of individuals touched by such state action. Clearly, regulated implementation of fundamental rights within the framework laid down in Part Roman 4 needs to be viewed in contradistinction with enforcement of such rights. This then could be called the fulcrum on which rests the dynamism of the role played by the directive principles of Part 4 in implementing the rights under Part Roman 3. On this note, I must add that our journey of nation building has begun on the right note. Why the implementation of fundamental rights by way of affirmative and voluntary state action with corresponding reduction in need for the enforcement of such rights would be a better way ahead for our republic. Ladies and gentlemen, thank you and Jai Hind. And my apologies, I won't be here for the rest of the two lectures. I would miss the participants, but my presence is required elsewhere, so I beg for permission to leave. Thank you.
Thank you, my